Welcome everybody. I'm Brian Tuck. This is Tuck's Rules. Today we're talking about blended families and estate planning and also the administration of creative properties. Ready? Let's go. When musician Tom Petty passed away in 2017, he left behind a blended family. What is a blended family, you ask? Quite simply, a blended family is a partnership or a union or a marriage between two people. That couple may have children together, but they certainly have children from prior marriages, prior unions, or partnerships. Now, most people find a way to make this arrangement work very well during life. However, when one of the parents passes away, blended families, not unlike quote-unquote traditional families, can become extremely dysfunctional when an estate is being administered. In the case of the late Tom Petty, there is a significant body of work in terms of unreleased musical recordings, copyrights, trademarks, and intellectual property to be administered for a period of years and even decades going forward. Remember that the duration of a copyright in the United States is 70 years plus the life of the creator. So in Mr. Petty's case, those copyrights that his estate may own would continue in force till the year 2087. No matter how much you want to encourage the survivors of your estate to work together, you cannot force them to work together. And when you're drafting your estate documents, one of your objectives should be to leave behind very, very clear instructions as to exactly what is supposed to happen to your assets, how they are supposed to be administered, and the scope of the authority of any of your trustees or your executor over your assets, and how to best leverage those assets going forward. There are several takeaways from this situation for people that are in blended families. Number one, if relationships are tenuous among step siblings and step parents during life, those relationships will likely not improve once you have passed on. Work on those relationships while you can. They're so very, very important. Two, people can and will do unpredictable and unreasonable things when there are estate dollars involved. The larger the money, the more unreasonable and extreme the behavior may become in terms of filing contests in court and prolonged orphans court litigation that will only serve to deplete the estate assets. Third, clearly drafted estate planning documents are your best path forward in terms of minimizing the chance that there will be litigation after you have passed. For everybody's benefit, the estate planning documents should be drafted in a very clear and unambiguous way. I hope this video was of help. In part 2 of this essay, we're going to talk about how to administer those creative properties in your estate after you have passed on. If you have songs, books, anything that is copyrighted, or you own trademarks, or you have a family business that is a significant organization, you should check this out. Please subscribe to the YouTube channel, share with a friend, and if you have any questions, of course, you can please email me or DM me if you're watching this on Instagram. I'll talk to you soon. I'm Brian Tuck. Thanks for watching. Be good.